SJC-11709, Commonwealth v. Bryant Ware.
Good morning.
Good morning, Your Honor. May it please the Court. James McKenna for Bryant Ware. I'd like to spend my time answering some of the concerns this Court has raised during the Cotto matter and any questions the Court may have now.
Well, did you ever allege that Farak had been the analyst in any of your clients' cases?
Yes, Your Honor. In the 2009 case, the middle case of the three. Our concern is to address essentially sequentially the questions raised by the Court. When Justice Cordy presented the question about who was dry labbing back in 2004, on page 264 of our record appendix, we do have a chart that indicates that Dukin at that point had over 9,000 results reported in the 7 months she worked with, which was far beyond anyone else in the lab in 2004. In those 7 months she worked with Ms. Farak had more than 1,400 more results than Dukin.
But moving to Amherst, that's still in Hinton, right?
Yes, Your Honor. I'm just answering questions as they came up. So that would suggest she was outproducing Dukin at a time when Dukin's results were far greater than anyone else at Hinton. She then moves to Amherst and is essentially unsupervised. To Your Honor's question about the investigation, on January 18, 2013, her hapless supervisor stumbles upon 2 cases in which Ms. Farak had taken evidence. They call the state police. They arrive that day. They find 2 more. And that's when the investigation ends. Those are the only 4 cases with which Ms. Farak is prosecuted. That's it. There's no...
Well, just on that point, is there any evidence that before that, I don't know, did somebody look at the records of the evidence officer in terms of, as I read it, it seemed as though that was the first time in her experience she hadn't been able to account for samples.
The other supervisor there spoke about how she could have been doing this for years. And in the Rodriguez brief, which is an amicus brief submitted here, it describes her at work in 2011, and she's discussing whether or not she's going to use samples that day. She'll be alone in the lab in the afternoon, after lunch, and she feels like using more cocaine. That's what's in the Rodriguez brief. That's 2011. With respect to Your Honor's question about July 2012, that date was chosen because of a random finding haphazardly of 3 cases in which she did the same thing she did in January, switched cocaine for soap. That's why the Court said, okay, we know she was doing this in July. We don't have evidence from before then. That's why we have the motion in Ware. We want the evidence. The investigation should not have, for every practical purpose, stopped on the first day.
Now, when you say the investigation, what about the testimony we've just heard about concerning the state trooper's audit?
The state trooper's audit was flawed for our purposes because the state trooper did not know of the results of any random retesting done since she got there. They just didn't have the data.
What did the state troopers do? What did that audit consist of? I mean, did they not go in and do the same things that were done during the Hinton audit of the audit of the Hinton lab?
To a limited extent, they did. They talked about whether there were quality controls, about when the substances came in and whether they were weighed and what happens when there's a discrepancy. Those questions were answered, but they didn't have the data. They didn't know what happened to the drugs which were tested during the time Ms. Farak was unsupervised and in the lab.
And could they have done that? How could they have done that?
They could have done retesting. They could have done the retesting Mr. Ware is asking for, just random retesting.
Of available samples? But what about the destruction of evidence on of narcotics that happens on a regular basis?
Your Honor, in our motion, we attached the 2 separate protocols, the policies, which we obtained from the Springfield Police Department, the 2 separate procedures they use to destroy evidence, essentially. None have been followed. If the evidence is no longer around, It has been destroyed in violation of their policies, and we have another motion on the way.
Did you request retesting in your case?
Yes, Your Honor. We
A
requested it from...
specific motion for that?
Yes, Your Honor. That's the essence of our motion. Our retesting from 2004 onward.
Oh, no, you requested retesting of everything done in the last 10 years. How about your case?
Yes, Your Honor. Oh, everything done at the lab since 2004.
No, your case.
Yes, Your Honor, in our case.
No, the
Your
testing of
clients,
the
of your
drugs in your
clients,
case.
the stuff that was taken from your client.
We did not ask for that.
Why not?
Because we're looking, that's not our case. Our argument is
Your case, actually.
that the conclusive presumption found in Dukin should apply here, that...
But if you can get to analyze the evidence in your case and show that there was something wrong with it, you don't have to be concerned about the rest of the world.
We don't. But our argument is, as this court recognized in Scott, it's impossible to credibly recreate the record after Dukin had tampered with the evidence. We have the same situation here, apparently. We need...
But you might not.
We might not. We'd like to know. And that's why we're here asking this...
But don't you start with what you do know first? I mean, what if it came back that there was no controlled substances in the retesting in your case?
We could have taken that approach. What we said was that everything Ms. Farrak did while an addict working unsupervised in the lab is suspect, and everything should be thrown out. It's the beef stew argument, Your Honor, that if you find a bandage in the beef stew, you don't pick out the bandage and eat the rest because this one's okay and this one's okay. This piece of stew is okay. You throw the whole thing out.
Yeah, but why launch a crusade when you can go home today?
Because we only, in the record, have established that one of the three of Mr. Ware's cases concern Ms. Farrak. The other two are in the lab generally. And we would like, frankly, we're relying upon that conclusive presumption.
And is there any evidence that anybody else apart from Ms. Barak was involved in wrongdoing?
That's the problem. There's no evidence because there's been no testing. We just don't know what happened there.
But you don't have any predicate. I mean, there's a predicate, I understand, to do some retesting with regard to Ms. Barak's work. What predicate is there to do retesting of anybody else's work?
She was alone in the lab, using drugs alone in the lab. And that's our concern as to what she would have accessed. Without supervision, everything there is potentially suspect. We just want to know, that's all.
But you're looking for every sample sent by the Springfield PD to the Amherst lab from 2004 to 2013?
No, we asked for a reasonable testing regime to be put together by the court, and we suggested 200 per year.
That's not what I read. I mean, visually inspect all samples, randomly select 100 samples from 2004 and then 200. In each of the year, you're looking for about 1,200 retestings.
In terms, if I can quickly break that down, because I know I'm out of time. In terms of what we're looking at is look at everything, because you can see, just by looking at the samples, you can see the soap. And you can say, okay, there's soap we can see in these set of samples. Otherwise, we're asking for 200 a year randomly, or some number the court deems appropriate, from 2004 onward, to be actually physically retested. The others inspected. Everything that came in should be looked at, because if she's switching cocaine for soap in January of 2013, in July of 2012, there's no reason at all to believe she began in 2012. In fact, it would be remarkable that without comprehensive retesting, they happened upon the first 3 times she did it.
Are you saying that that some of these things are just sort of available for visual inspection, and visual inspection alone would tell you whether or not some of these things have been adulterated?
Absolutely, yes, Your
You
Honor.
wouldn't really need a more sophisticated test than that?
Absolutely, yes. The soap is visibly different than the cocaine.
So you wouldn't need anything more than that. Is that what you're saying?
We would ask for both. We've asked for everything since 2004 to be looked at, and a random substantial number to be tested, because we don't know what she was doing 5 years ago. And, Your Honor, thank you very much.
So good morning again, Your Honors, Catherine Robertson. With respect to Mr. Ware, I'm going to speak about Mr. Ware's case. Out of the 3 indictments that were pending against him, there's only one in which he has alleged that any testing was conducted by Farrak. That's the 2009 indictment. He has not requested that that sample be retested, but and I have told Mr. McKenna this, the sample does still exist. and could be retested. So that sample has not been destroyed.
Could you sort of expand on the whole idea of what is available for retesting? I mean, it seems to me that what Council's saying is that there are any number of things still extant in the lab from 2004 onward. I mean, it would be helpful to know what the universe of the possible is.
It might be helpful to know what the universe of the possible is, but I cannot tell you that, Your Honor. And let me say that at the lab itself...
You don't know whether these things exist that we're
Only-
arguing about?
Not the things that Mr. Ware has requested be retested. So the lab itself doesn't hold on to samples. The process is the police department submits a sample to the lab for testing. It batches of samples to the lab for testing. The samples are tested. The police department is notified that the testing is completed, and the samples are returned to the police department, which maintains then custody of the sample until the time of trial or until the case is otherwise disposed of. So the samples don't stay at the lab. They go back to the police departments where they originated after they're tested. So there's not going to be, there may have been sort of a set of samples in the lab at the time that Farrak was arrested, but in terms of historically establishing the scope of her misconduct, that's going to be of sort of limited value because those are going to be sort of contemporaneous with, the fact of her arrest. And what individual police departments dispose of or don't dispose of is, I cannot tell you how any police department does it and how many samples they keep on hand and how many samples, when they do their destruction. We would have to go back to each police department and find that out. And it was, we did inquire about the samples in the 5 cases that were Mr. Ware's case and the other 4 cases that were the subject of the request for direct appellate review here. And I can't even remember about the other 3 cases, but I do know that Mr. Cotto's sample had been destroyed and Mr. Ware's sample had not been destroyed.
Does the record indicate approximately how many cases Farrak is responsible for out of the Amherst lab in the 10 years she worked there, or however many years she worked there?
No, Your Honor. There is an affidavit saying in total she had conducted 29 analyses, and it breaks it down between drugs, but presumably that encompasses...
29 what? 29?
29,000. Okay. But presumably that encompasses what she did at the Hinton lab, and it doesn't, there is some breakdown between the different kinds of substances that she analyzed as well. But
Is there a duty once law enforcement discovers that there is this type of problem to do an internal investigation to examine its scope?
Well, if there is that duty, Your Honor, I think it would have to be a duty that was perhaps established by this court. I mean, I don't know a source of responsibility to
Okay,
do
so I'll rephrase the question. Should we establish
Should you
some duty of
establish some
internal
duty?
investigation?
Well, again, we've argued it at least with respect, and I think it's a fair point, that at least with respect to the kind of misconduct that we have here, it's appropriate to put a burden on the defense to at least establish that the misconduct, antedates whatever event it was that, gave rise to the conviction, whether it's or the testing that gave rise to the conviction, whether it's a guilty plea or a trial, or to request retesting if they believe that the sample was not, was possibly contaminated, and that we didn't get, the Commonwealth didn't get those motions. And I believe that in the, sort of currently pending cases from 2011, 2012, those samples likely do still exist. And to the extent that a defendant wants to raise that, the samples could be retested. Funds could be sought. There could be a defense expert appointed. And, so, I mean...
Let me just ask you, following up on Chief Justice Gantz's question, though. When was Ms. Farrak arrested?
December of 2013, Your Honor.
And when was this learned of, that there was a problem?
Then. I mean, it was really, in other words, January of 2013. So they discover, at that point in time that there are samples missing. She's arrested almost immediately, but that's really when
That's in 2013, beginning of 2013.
Right.
So is there anything locked down at that point?
The lab was locked down at that point. The lab was locked down at that point.
But this was all, this is all coming to light after everybody has been wringing their hands about the Hinton lab. So,
That's correct,
I
Your
mean,
Honor.
so it's coming in a context.
It's coming in a context. It's also coming in a context of, substantial demands on resources of investigators, and, and I understand that that's a concern, but that, and a more limited form, a different and a more limited form of misconduct, a form of misconduct that probably could be established. We don't have any reason to believe that if she did tamper, that we couldn't sort of figure that out as long as the samples still exist. And there's not really evidence of misconduct that covers the entire span of her career as a drug analyst.
But I take it from what you said earlier. If you look at what happened in the Dukin case, and you look at at least the potential evidence of misconduct and the motivation for it. In Dukin's case, she had those high numbers of over many, many years, and there was a motivation for doing what she did that defined the scope of the investigation. Here, what we have is evidence that she was behaving differently beginning in July of 2012, and the way she was using or not using the ladies' room and associating with other people and leaving early and whatever, coupled with the I forgot what the other thing was. What it was coupled with. Her use of cocaine, the missing samples, the period of time that defined the investigation was essentially July of 2012 up until the end of 2012.
Her odd conduct in the lab, even her coworkers would put a little bit later. They sort of said beginning around September, but it was the retesting, I think, that caused the judge to think that it was pushed back because he found adulterated samples, pushed back to July. I wanted just briefly to, with respect to Mr. Ware's motion, again, the sample would still be available for retesting, but there is still the second prong in Ferrara. That's, the question is always whether, with a motion for post-conviction discovery, whether it would support a meritorious claim for a new trial. And I would rely on my brief for that.
But aren't you arguing something that's not before us? I mean, he hasn't filed the motion for new trial yet.
Yes, he does. He has filed a motion for a new trial, Your Honor.
But it's not ripe for decision. What's before us has to do with the discovery.
But it was a basis of the judge's decision that it would not support. It would not support a meritorious motion for a new trial, because if you look at the second prong of Ferrara, this is a case. If ever there was a case where his guilty plea, he would have been. It would have been really imprudent.
Theoretically, there is somewhat of a problem with that, because it seems to me a defendant is in a different, and a judge in weighing those, balancing those things, is in a different position if there is a reasonably full exposition of what the misconduct was. If the defendant is kind of sitting on a half-baked investigation, it's harder to know.
Well, but still, it's always going to be. It is the defendant's own case, but here, Your Honor, there's only one case. He was facing 2 indictments, and if you look at the charges against him, there were drug charges in the 2010 indictment where there's no claim that Farag was an analyst. There were 5 counts of. It's a case where if you look at the factors that were set out in Scott, they were pretty overwhelming in support of the notion that given his exposure. But in any event, if we're looking at discovery, it's still, is the discovery going to support a meritorious post-conviction motion by this defendant? I don't think he is really entitled on the basis of Rule 30 to sort of appoint himself a private attorney general. And I can tell you that I don't think the Commonwealth really in any case would oppose a motion for retesting if the sample still existed.
All right,
Thank you, Your Honors.